Welcome to the Singapore International Arbitration Center's virtual New York office launch. I'm Adriana Uson. I'm the head of SIAC's Americas office, and I will be your host for this program. Thank you for joining us today, and I hope everyone is keeping safe and well. It is my pleasure to invite Mr. Devinder Singh, Senior Counsel, to deliver the welcome address. Mr. Singh is the chairman of SIAC and the executive chairman of Devinder Singh Chambers, LLC.
Minister for Home Affairs and Minister for Law, Singapore, Mr. K. Shanmugam. President, SIAC Court of Arbitration, Mr. Gary Vaughan. Fellow members of the SIAC Board of Directors and members of the SIAC Court of Arbitration. Distinguished guests, friends, ladies and gentlemen. Good evening, and wherever you may be in the world, welcome to this launch of the SIAC Americas New York office. This is a momentous occasion for SIAC. We are therefore deeply honored that the one person who has been instrumental in putting Singapore on the international arbitration map, Minister Shanmugam, has agreed to be the keynote speaker. We are also very honored that Mr. Gary Vaughan and members of the SIAC Board and SIAC Court of Arbitration, as well as arbitration luminaries from all over the world, are here with us today. At SIAC, everything that we do is shaped by our mission to enhance Singapore's standing as the most trusted place on this planet for dispute resolution. SIAC is part of a whole of country effort. The executive of the government continually reviews and revises its policies and laws to ensure that Singapore will always have the best ecosystem for investments, businesses, and financial and legal services. Singapore's institutions and agencies work tirelessly to give substance to Singapore's promise of integrity, stability, predictability, and the rule of law. The legislature passes arbitration laws that keep us one step ahead of the rest, while the judiciary, comprising highly respected local and international jurists, is a thought leader in the field, shaping developments in international arbitration through its groundbreaking and thought-provoking judgments and speeches. For a long time now, SIAC has been very conscious of the importance and weight of the Americas in international arbitration. Therefore, the opening of our New York office is a very exciting and significant milestone for SIAC. That New York will be our first representative office outside of Asia is an acknowledgement that the Americas will be shaping much of the future of international arbitration. SIAC is witnessing a growth of users from the US. In 2018, the US topped the foreign user rankings. This year alone, there are over 500 US parties arbitrating at SIAC. We've also seen an encouraging and growing number of Latin American and Caribbean users at SIAC. We want to have far more engagement with you. To our many friends and supporters in the Americas, the opening of our New York office is our way of showing you that you matter to us. SIAC is what it is today because of the invaluable support and contributions of the SIAC Board and SIAC Court members. They are leading practitioners and arbitrators from all over the world. Despite their busy schedules, they give so much of their time and ideas to SIAC. I am very grateful to them. I also want to thank the Chief Justice of Singapore, Mr. Sundaresh Menon, Ministers Shanmugam, Indrani Raja, and Edwin Tong, Attorney General Lucian Wong, and my dear friend Gary Vaughan for their extraordinary leadership and support. Without them, SIAC will today not be playing with the big boys. My gratitude also to the first-rate management and staff of SIAC. They have worked tirelessly to make today's launch possible. I would also like to introduce our head of the Americas, Adriana Uson. Adriana was a counsel at the SIAC secretary and will do a great deal for us in the Americas. It is with great pleasure, therefore, that I can say that from today, SIAC is now also on Eastern Standard Time. Thank you.
Thank you, Mr. Singh. We are greatly honored to have with us the Minister for Home Affairs and Minister for Law of the Republic of Singapore, Minister K. Shanmugam, SC, to deliver the keynote address.
Mr. Devinder Singh, Senior Counsel, Chairman of SIAC, Mr. Gary Bond, President of the SIAC Court, distinguished guests, ladies and gentlemen, good evening. Today is an important milestone for SIAC. It marks the official launch of SIAC's New York office. SIAC has done very well over the years, more than 400 cases annually in the last 3 years, involving parties from 59 jurisdictions. US parties are consistently one of SIAC's top 10 foreign users in the last 5 years. And in 2018, the largest number of cases came from US parties. So it has been SIAC's intention for some time now to open an office in the US. There is significant demand, as seen from the caseload breakdown, since 2014. And of course, US direct investments in Asia Pacific exceed US $800 billion, and that is expected to grow further. And in this part of the world, arbitration has become an extremely important means of resolving disputes, which may arise from investments. And if you look around Asia, I think most people will agree, SIAC is considered the top arbitral institution. And in that sense, opening of the US office of SIAC is a long overdue step, and it's an important step for SIAC. SIAC has been successful in its work because it has been able to help parties resolve their disputes fairly, efficiently, cost-effectively. Let me say a little bit about SIAC. Its panel comprises over 500 experienced arbitrators from more than 40 jurisdictions, some of the top arbitrators in the world, both common law and civil law experts. And in Singapore, parties are free to choose any arbitrator, counsel they wish. There is minimal intervention from the courts. There's a framework for it, which is clear. And therefore, it is extremely common to see US counsel and other foreign counsel and parties in Singapore handling disputes which has got nothing to do with Singapore. People also want their arbitration to be done in a timely manner, besides having counsel of their choice. And there again, SIAC does well. A 2018 study by an international institute shows that SIAC arbitrations are the most efficient compared to other arbitral institutions. And they studied the statistics from the arbitral institutions themselves. The mean duration was 13.8 months, shown to be shorter than many other institutions. Parties can also avail themselves of SIAC's emergency arbitrator provisions, SIAC's expedited procedure, as well as a procedure for early dismissal of claims and defenses. The same study also concluded that SIAC remains significantly less expensive than many other comparable jurisdictions. SIAC is growing from strength to strength. This year, another record, 1,005 cases as of 30th of October 2020, though it does include 2 sets of cases, which we call packs of cases, filed for related contracts, and those 2 sets have a very large number of filings. But congratulations are due to SIAC on this achievement, and it's due in no small part to the successive chairmen and presidents we have had, who have all made SIAC extremely important institution in the arbitral world. And now, of course, Mr. Devinder Singh and the president, Mr. Gary Bond. Both are prominent figures in the international arbitration field. Their visionary and strategic leadership has helped SIAC, and who have contributed tremendously despite their busy schedules, and they are constantly working with their teams, working on how to bring SIAC to even greater heights, and we are very grateful to them. SIAC manages many cases from different jurisdictions, and it's well supported by a multinational secretariat, lawyers qualified in several key jurisdictions, including the US and Canada. The cases may have nothing to do with Singapore, may not even be using Singapore law, as I said earlier. Even so, Singapore is chosen as a seat of arbitration. And again, in the world, Singapore is now the third most preferred seat of arbitration, and it ranks among the top 4 in all regions except Latin America. And I think there are good reasons for it. It's got a trusted legal system, a supportive judiciary, and modern progressive laws, which we regularly review to keep updated with international best practices and commercial developments. We will continue to strengthen our legal framework for international arbitration, maintain its relevance to businesses. Congratulations to SIAC once again on the launch of your 5th overseas office. Today's launch is just the beginning, and looking forward to many more successes in the years to come. Thank you.
Thank you, Minister. I would now like to invite Mr. Gary Bourne, President of the SIAC Court of Arbitration and Chair of the International Arbitration Practice Group at Wilmer, Hale, and Ms. Lim Sok Wee, CEO of SIAC, to deliver the message from the President and the CEO.
Thank you. Thank you for attending this launch, this virtual launch of SIAC's United States Representative Office. We picked the United States, we picked New York as the location for our first representative office outside of Asia for 2 reasons. Both Singapore and the United States are vibrant, energetic, and highly diverse societies. If you walk around the streets of Singapore, you could think you were in Los Angeles, in Houston, Miami, or New York. You might also think that you were in Sao Paulo, Rio de Janeiro, or Buenos Aires. The second reason that we chose the United States as the location for a representative office is because US users have found SIAC arbitration so conducive to the resolution of their business disputes. US users have been among the most frequent users of SIAC arbitration over the past decade. In 2018, more US parties than parties from any other jurisdiction in the world arbitrated under the SIAC arbitration rules. This year, in 2020, already, more than 500 US parties have arbitrated their disputes under the SIAC arbitration rules. And as Minister Shanmugam emphasized in his opening remarks, more than 1,000 SIAC arbitrations have been commenced this year in 2020 already. It's a record for our institution. It's a record for almost any of our competitors as well. We look forward today not just to the launch of SIAC's representative office, but to the beginning of a long-term cooperation, a long-term collaboration with our US users. We're in the midst of the revision of our 2016 SIAC arbitration rules. Those rules are already at the cutting edge of international arbitration practice. They've included many procedural innovations that very few of our competitors offer. We welcome comments from users around the world. We're consulting widely with our users, both in Europe, in Asia, and elsewhere. We're looking forward in particular to your contributions.
Our people are the cornerstone of SIAC. Our board is chaired by Mr. Davinder Singh, one of Asia's most accomplished litigation lawyers, and includes eminent corporate and legal experts. The SIAC Court of Arbitration is led by Mr. Gary Bourne, one of the world's preeminent arbitration practitioners, as our president. We have benefited and will continue to benefit from the expertise of our court members, who are leading international arbitration authorities from all over the world, including the United States and Latin America. We also have a multinational team of experienced lawyers in the Secretariat, headed by our Registrar, Delphine Ho, and our Deputy Registrar and Center Director, Kevin Nash. Our lawyers are qualified in the US, UK, Singapore, China, India, and other jurisdictions. We are able to administer arbitrations in languages other than English and have administered bilingual arbitrations in a variety of languages. We have over 500 arbitrators from over 40 jurisdictions on our panel of arbitrators, which includes many household names from the US and Latin America. The panel is a published list. You can find the names and profiles of our arbitrators on our website. As part of our continued commitment to deliver world-class services, we work closely with our Users Council worldwide and in the Americas on important initiatives such as the ongoing rules revision. We invite young lawyers in the Americas to join the Young SIAC community and to organize, participate, and connect through our various programs and workshops. Today's launch of our first representative office outside of Asia is a special milestone for SIAC. Adriana Uson will head up this office. She brings a unique perspective to this role, having worked for several years and administered hundreds of cases during her time as counsel at SIAC, and having also practiced as an international arbitration lawyer at a top global firm. We have many exciting plans lined up in the coming weeks and months for the US and Latin America. As always, we welcome your views, comments, and suggestions. We hope to count on your continued participation and support. Thank you.
Thank you, Mr. Bourne and Ms. Lim. We will now move on to the virtual office launch ceremony. SIAC Americas is now officially open. Moving on to our panel session, we are very fortunate to have an esteemed panel of experts who will join us for a speed round, 60 minutes on the state of play in international arbitration in the Americas. This will be a fast, free-flowing session where the panelists will take on some of the significant issues in contemporary arbitration practice. The panelists for the session are Mr. Chan Leng Sun, Deputy Chairman of the SIAC Board of Directors and Senior Counsel and Arbitrator at Essex Court Chambers, Duxton. Mr. Nigel Blackaby, Queen's Counsel, member of the SIAC Court of Arbitration and a partner in the Washington, D.C. office of Freshfields. He is global co-head of the firm's International Arbitration Group and co-head of the Latin America Group. Ms. Julie Bedar, member of the SIAC Court of Arbitration and the head of Skadden's International Litigation and Arbitration Group for the Americas. Ms. Karina Goldberg, partner at Ferro, Castro, Neves, Daltro, and Gumide. Ms. Tafadswa Paspanoja, a partner in the Washington, D.C. office of Foley Hoag. She co-chairs the firm's Africa Practice Group. Moderating the panel discussion is our president, Mr. Gary Bourne.
Welcome. I'd like to begin by thanking Adriana for the very gracious introductions. The panel members deserve no less. I'd like to thank them as well. They're leading experts in their fields and making themselves available for this webinar on the occasion of SIAC's opening of its Latin American and US offices is very gracious. Most of all, though, I'd like to thank all of you, all the attendees, those of you who are spending your time to listen to us discuss SIAC's US and Latin American launch. We chose to open our first non-Asian representative office in the United States and Latin America because of the similarities between those two parts of the world. If you walk around Singapore, it looks a lot like Sao Paulo or Miami. It looks a lot like Los Angeles and New York, a lot more than Paris or London do. With that opening, let me turn to the members of our panel. They are going to discuss recent developments in international arbitration. They're going to do so in a speed summary form, touching on a number of topical developments, just for a few moments each. I'd like to begin with Leng Sun, who's going to address procedural reforms, procedural developments over the past 5 years or so in international commercial arbitration. Leng Sun?
Thank you very much, Gary. Thank you. If we're talking about procedural reforms, I think that a universal and increasingly emphatic concern of end users of arbitration is cost, and related to that is time spent and delay in arbitration. There are many factors contributing to high cost and delay in arbitration, just as there are many creative approaches that arbitral tribunals and arbitration institutions can take to minimize cost and delay. Today, I'll just speak on one, since this approach or this format is about speed, and that is expedited procedure. I would like to share first the SIAC experience, because SIAC in this part of the world, at least, is a pioneer of expedited procedure. I will then maybe touch on what other institutions are doing. SIAC started expedited procedure in its rules in 2010. And as of October 2020, this year, there have been a number of 605 applications received, out of which 349 applications for expedited procedure were granted. So it's a very considerable number. And the rationale that informs the SIAC approach is this: arbitrations that come before SIAC often involve disputes arising from significant transactions. Many corporations involved in a significant deal, whether it's a one-off sale and purchase or an infrastructure project, want to be assured that if a dispute arises, the quality of the dispute resolution process and decision-making will be fair and good. And that is why most contracts involving substantial transactions will provide for a tribunal of 3 arbitrators rather than 1. They will also select a set of rules that does not limit their right to a full hearing or full opportunity to prepare their case, such as SIAC rules. However, even though a contract can be significant, the dispute that arises may not be. If a relatively modest claim arises, it may not make sense to go for a full conventional hearing where you leave no stone unturned. And the ideal solution for parties, therefore, is that they may agree to 3 arbitrators at the time of contract. But if the dispute turns out to be a modest one, either of them should have the option to ask the arbitral institution to appoint just 1 arbitrator under an expedited procedure. And that is the SIAC approach. And that is the rationale. If parties opt for SIAC rules, parties are also agreeing to the application of the SIAC expedited procedure. And if the conditions for expedited procedure apply, then the arbitration shall be before sole arbitrator, unless the president of the SIAC court decides otherwise. And the procedure expects that an award is rendered within 6 months of the constitution of the tribunal. And that's why usually you require 1 arbitrator, so he or she can move along quite fast. And that is a very significant philosophical approach, because this is an approach that provides for flexibility, where corporations can choose 3 when they make the contract. But depending on the circumstances, they may find that 1 arbitrator will suffice. There are a number of other arbitral institutions that have expedited procedure. They all take varying approaches, so you have to be careful because it's not one expedited procedure with one single format that is universal. And maybe I should stop here, Gary, in case you have any questions that you want to raise.
That's very interesting, Leng Sun. Can you remind us again, what are the criteria for when an expedited procedure, an EP case can be put on a fast track?
There are 3, any one of the 3 will do. And that is if the amount in dispute does not exceed Singapore $6 million, excluding interest and costs. That, as a rough guess, would be just about US 4 million maybe, or thereabouts. Or if both parties consent, all parties consent, or in case of exceptional urgency. So any of this will do for EP to kick in.
And what would be examples of exceptional urgency? When might the court invoke that provision?
I think it may be that a substantial dispute is one that needs to be resolved quickly. It's not just a matter of an interim order, where this entire dispute, for example, deals with goods that are perishable, and you need to come to a final decision on what should happen with the goods. That might be one example where it's a case of exceptional urgency. And in fact, Gary, you probably would have a better overview of this, since these questions come up before the SIAC Secretariat and to the president of the court. I myself believe that there are not that many cases which are granted on the exceptional urgency basis for EP.
That's certainly been our experience at the court. It's much more frequent that either the parties agree, a surprising number of cases, parties actually agree, irrespective of the amount in dispute, to put it on a fast track and use the expedited procedures. The most common, of course, is the smaller value disputes, when the disputes are less than, as you say, $4.5 million US. Nigel, your thoughts about expedited procedure. Is it something that's useful for commercial parties, something that we should be cautious about?
So I think it's critical to maintain the credibility of international arbitration in the commercial community. And we've really strayed so far from the original understanding of arbitration as a quick and efficient means of resolving disputes in the commercial world into an ever more lengthy and ever more costly proceeding. So I think given this option to clients at the moment of their dispute, I think is a very valuable tool, particularly when so many disputes are linked to issues that are urgent. I'm quite frequently involved in post-M&A disputes where it can be a question of whether closing conditions have occurred or whether or not certain indemnities need to be paid. And companies want to move on, and they don't want to be dragged into 3 years of process. So I think this option when the dispute arises is so valuable because, of course, when the contract's drafted, everybody's thinking about the worst possible dispute and want to make sure they're protected for the bet the company case. But most disputes are not bet the company cases. And then when you're faced with a 3-member tribunal, scope for delay is so much more increased and it becomes sort of a victim of that process. So I think it's a very valuable tool, particularly together with the emergency arbitrator provisions, which permit rapid interim relief, which again, I think was another bugbear of international arbitration for the commercial world. We need interim relief pending the answer. But together, I think this has made arbitration a much more flexible tool and much more attractive for the resolution of commercial disputes.
That was certainly the reaction of our users, SIAC's users, when we consulted fairly widely among businesses, among law firms in 2016, when we revised the SIAC arbitration rules. Incidentally, we're in the midst of that process again. All of the attendees here, all of those of you watching this program are invited to participate, provide comments on the SIAC arbitration rules. We're always seeking to keep them at the forefront of best practices for international commercial arbitration. And your thoughts, whether about expedited procedure, emergency arbitration, or another procedural innovation are always welcome. One point, Langsun, that Nigel raises is other mechanisms for saving time and money. The SIAC rules, of course, have, as Nigel mentions, the emergency arbitration provision. They also have early dismissal. Could you say just a couple words about each of those before we move on to issues of third-party funding?
Well, yes, those are the 3 features of SIAC arbitration that are commonly discussed because they are not quite your conventional arbitration features. Emergency arbitrator or emergency arbitration, I think the more correct, description of it is an emergency arbitrator because it's not the entire arbitration that is conducted on an emergency basis. The idea is that if a party needs urgent interim relief, and the tribunal has not been constituted, you want to offer them a chance to go before arbitration, to have an arbitrator appointed very quickly just for that purpose, to deal with interim reliefs and interim applications. SIC rules have been amended to provide for an emergency arbitrator to be appointed within a day, not even a working day. So if you ask for an emergency arbitrator on a Saturday, the secretary will give you one by a Sunday, because everybody knows that the council and members of staff at the SIC Secretariat do not sleep, and that they work pretty fast on that. The other feature that was introduced is early dismissal, and this is an idea that's taken from exit arbitration, where either party may apply for early determination of issues that could dispose of the case, whether it is the claim itself or a defense. And this is similar to striking out of a claim or defense, but only if it's manifestly unsustainable without legal merit. So that's the idea for early dismissal. Gary, if I may, bring this to the larger stage. These ideas of saving time and cost, of course, have permeated discussions at many levels, including the global level. And at UNCITRAL, looking at the success of expedited procedure at the SIC level and other commercial arbitration institutions level, UNCITRAL is now considering what to do with regard to the UNCITRAL rules, and should UNCITRAL itself have a set of expedited procedure. That has been a project of the working group for a couple of years, but UNCITRAL, of course, has its own challenges because there's no secretariat administering an UNCITRAL arbitration. So some of the features of expedited procedure that you see in SIC or other arbitral institutions, like decision on the applicability of expedited procedure, the appointment of the arbitrator, cannot be so easily done. So UNCITRAL is trying to be creative to see how it can fit in to the UNCITRAL ad hoc arbitration model. And that's a work in progress.
That's a real challenge, because one of the points that we didn't mention about expedited procedure, in addition to the court's discretion whether or not to put a case onto the expedited procedure fast track, is the registrar's ability to take a case out of expedited procedure. It doesn't happen very frequently, but in some circumstances, a case that looked really small and really simple turns out, in fact, to be complicated or much larger than anyone anticipated. In those circumstances, the SIAC rules have a safety net, if you will, that allows the tribunal to request the registrar to allow it to put the case onto the normal timetable as opposed to the fast track. We think it's important for the party's right to be heard to have that option, even if it's not used very frequently. UNCITRAL faces a real challenge if you don't have a mechanism, if you don't have an institution that can perform that function of unfast tracking, unexpediting a case that's been on a fast track.
Currently, the proposal is, for the tribunal itself to decide whether to take it out of the fast track. But you're right, there are many challenges, and they have to approach the problems slightly differently from an arbitral institution.
Yeah. Interesting. Why don't we move to our next topic, third-party funding, an issue of much concern both to clients and also lawyers. I'm sure all of our users are interested in it. Karina, your views on recent developments in third-party funding, both in commercial and investment arbitration.
Yes. Hi, Gary. Thank you so much for the opportunity, for the invitation, for being here with this great team of experts. I have to say that Brazil is very peculiar and unique regarding foreign investors in comparison with all the other Latin American countries. And we still don't have BITs, enforceable BITs that for investors could adopt to file their claims against the state. But what is very on demand in Brazil, and we have a huge number of cases involving a big amount of money, are cases that are brought by investors, stakeholders, individual, even like pension funds, investment funds, against listed companies. So companies that have their shares exchanged in the stock market and that have as controlling shareholders for the state, for example. So we have Petrobras here in Brazil, which is the biggest oil company, and we are having more and more arbitration claims that we even call it as collective claims, because you have a number of investors jointly filing the claims, because the bylaws of listed companies in Brazil require them to adopt arbitration as the dispute resolution method. So this directly has had an impact in third-party funding in Brazil, because most of these claims have a very high value, but they are brought by individuals or small investment funds. And third-party funding are more and more active in Brazil. Of course, that what we need here is to pay attention on conflict of interest issues, and the institutions do have to play a very important role here. We see as when we represent the defendant, so the company or even the controlling shareholders, we most of the time, right in the beginning of the proceeding, we ask the institution to inquire claimants, so investors, on whether they are being funded by third-party funders. We do follow IBA conflict of interest guidelines, and in Brazil, to keep the integrity of the award, we definitely need to know if those investors are being funded, because in the end, the third-party investor will be considered equivalent to the parties themselves. So even before the constitution of the arbitral tribunal, the institutions play an important role here. I don't know if you have any inputs from CIC and how does this work?
Thank you so much, Karina. That's interesting. Of course, an SIAC arbitration can be seated anywhere in the world. It doesn't need to be seated in Singapore. It can be seated in Buenos Aires, in Bogota, in Sao Paulo, or Rio de Janeiro. It sounds as if it's seated in Brazil, there are not restrictions in Brazilian law on the use of third-party funding. There's certainly nothing in the SIAC rules that would preclude the use of third-party funding. Just to move back to Leng Sun for just one moment, suppose that Brazilian parties or a Brazilian party and a US party seated their arbitration in Singapore. They don't have to, but suppose that they chose to do so. Could they use third-party funding there? Does Singapore permit third-party funding in international arbitration?
I think the question has become simpler compared to, say, 5 years ago, because the law in Singapore has been updated to allow third-party funding in international arbitrations. Prior to that, there's a question whether the common law tort of Champerty, maintenance and Champerty, will also strike down as a matter of policy contracts which are subject to funding on the basis that it's against public policy. Now, the law has been changed to say that funding would not render a contract to be contrary to public policy, provided that there are certain criteria that are met, including, for example, that the funder is a recognized professional third-party funder with sufficient capital. So the answer to that, Gary, is easier now, and that is it will be allowed in international arbitration. It is likely to be expanded to domestic arbitration, but your funder must be a qualifying third-party funder. And just to complete the point, Gary, the SIC also has a third-party funding practice note, which would be of use wherever the arbitration is seated.
Yeah. And I can certainly report from the perspective of the court, there have been SIAC arbitrations where there's been third-party funding. Karina, just coming back to you for a moment, how does it work? Does an arbitral tribunal have the authority? Should it use the authority to order disclosure of the existence of a third-party funder? If so, how far should that go? Should the tribunal be able to order disclosure of the third-party funding agreements?
Yes, Gary, the tribunal definitely has the authority to order the parties to disclose whether they are using third-party funders, especially because the tribunal cannot know in regard to conflict issues if they don't know who is the funder or if the party has the funder. They don't know, they don't have anything to disclose from the side of the tribunal. And this happens once the tribunal is constituted. Most of the time we do ask, if the parties have not yet disclosed it, we do ask them to disclose this so the tribunal can again check conflict issues. But besides of that, and as Langsam told, it is important to know whether which is the amount of the funding and whether the funder has sufficient financial capacity to make to be able to afford for the expenses of the arbitration. Right, in Brazil, most of the cases, depending of course of the rules of the institution, but most of the cases the losing party shall afford for all the costs of the arbitration. Those cases involving investors in the stock exchange are very big cases that with substantial issues that have an impact on a large number of investors, then also the figures are high. So there is always a discussion on whether the arbitral tribunal would have the authority and could ask for the funder and the party to disclose the amount and that is being funded. And I don't think that the commercial arrangement would be disclosable, and that maybe there would be some sensibilities regarding commercial issues, commercial secrecies, but at least the amount, I think the tribunal could require the parties to disclose, or at least if it's enough to cover the expenses of the arbitration and the legal fees of the other party.
Tafadzwa, I'm going to come just for one final question on this topic to you. The SIAC investment arbitration rules have in them specific provisions addressing third-party funding, addressing the tribunal's authority to order disclosure in those circumstances. We're in the process of consulting not about the investment rules, which have those provisions, but now about our commercial arbitration rules. Should we think about extending provisions like what we have in the investment rules to the SIAC commercial arbitration rules?
I think so. I think that disclosure is critical, really, because it allows the other party to be able to think about what the impacts of this funding will be on frivolous claims, and so what if the claimant actually loses? What are the options that the other party has to security of costs? And I think a critical aspect of disclosure is that it allows the other party to consider whether or not to ask for security of costs. And it's been really helpful that arbitrations have been more willing to consider security of costs when they've seen that there's a third-party funding agreement that doesn't allow the payment of costs should the party lose. So I think it's an important advance in investor-state arbitration that could also work really well in commercial arbitration.
That's a view we'll have to take into account carefully in the consultative process that's currently underway. Why don't we shift gears since you raised this topic and move to ISDS, both from a global, but also importantly for our viewers today, a Latin American perspective. Nigel, your thoughts about global ISDS developments and a particular focus on Latin America.
Thank you, Gary. Yeah, I think global ISDS is, in spite of multiple attacks from sort of multiple angles, still very much alive and well. We've seen how internationally, both within the European Union, the decision effectively to render intra-EU BITs unenforceable with regard to dispute resolution, with regard to the withdrawal of full access to ISDS in the USMCA, with regard to sort of almost to a degree political, a rare political bipartisanship against ISDS in many occasions. One would think that we're seeing the end of ISDS, but if you look at the figures, it's holding up remarkably well. And I think that's because states may have a certain rhetoric, but certainly states that are seeking to attract capital understand the importance of maintaining the treaties and maintaining the treaty network. So you see states which have withdrawn from bilateral investment treaties realizing what impact this is having, particularly on the small to medium-sized countries where there are other investment opportunities. And Ecuador is a good example, where treaties were denounced and where by the Correa regime and then the Moreno regime came back and started putting back the renegotiation of new treaties onto the table. Or you see the withdrawal from investment treaties giving rise to enhanced local investment protection laws, which aren't very effective, but again, realizing that you can't just have nothing, and that's pretty sort of Bolivia's experience. So I think it's alive and well because states that actually, where it perhaps matters most in the developing world, know that they're important instruments to attract foreign investment. And foreign investors still use them frequently and know how important they are when you have a radical change of government. And of course, we can see this whether it's in Mexico with the López Obrador administration with fundamental changes to the energy regime. You can see it with excesses of court intervention, particularly constitutional courts may come to discuss that later, where clear regulatory frameworks that have been complied with are being upset by decisions from constitutional courts, adding retroactively new criteria or different criteria to the possibility of projects moving forward. So I think at the end of the day, it's something which ensures the international rule of law, and it's been demonized for political purposes, but that ultimately it's something that enables capital to be attracted. It enables capital to move across boundaries to the benefit of developing infrastructure, developing fundamental needs of the people, whether that's in electricity, energy, infrastructure, and that's important. And I think ultimately people realize that and states realize that. So on a very macro perspective, I'm not worried about the health of the ISDS system. On a more micro perspective, of course, we've seen as administrations change, certain waves of cases diminish and other new waves of cases start. I think we're seeing much more now, going back much more to what it was in the first place, which was individual decisions which may affect investors in certain sectors rather than wholesale programs of expropriation and nationalization like we saw in Venezuela, or wholesale changes to public service contracts like we saw in Argentina. In Latin America now, certainly, we're looking much more at specific areas, specific sectors. Telecoms, electricity generation, and mining seem to be the flavor of the month in terms of intervention and effects. But certainly in Latin America, there's not really been much of a let-up. And perhaps a broader variety of countries are coming into the system. Those countries that set up their bilateral investment treaty networks later. Colombia has been sued very frequently over the last few years because its treaty network is being tested for the first time. And you see a broad variety of states responding. And as that happens, there's a greater knowledge and understanding of what international standards are and what it means to comply with them. And I've certainly been blessed when I've represented states to, as part of my mandate, to actually go and talk to civil servants and explain why it's important to give reasons for decisions, for example, why it's important to ensure that basic rules of due process are respected. And that's got to be a good thing, no? That there's an international standard applied to the way that governments behave. And we look forward to Brazil joining the joining the group, because We're bored with just doing commercial cases with Brazil. We'd like to do some investment cases too. Interestingly, of course, the Asian investment, one thing that I have noticed very frequently now is that we are dealing with so many more Asian investors into the region. We have a case at the moment for a Singapore investor against Peru. We're currently involved in another Singapore investor in a dispute in Colombia. Chinese investors. China is now the biggest foreign investor in Latin America by far, overtaking the United States. And China does have a reasonable network of treaties with Latin America, and we're going to see more and more disputes under that head as well. And clearly, the deep understanding of the SIAC in terms of Asian clients, Asian disputes coming into the region, I think will be of great value and something that the office will clearly help to educate the region and to hopefully bring under the umbrella of the SIAC many of these disputes.
Thanks so much for that, Nigel. The last 30 years or so certainly makes a powerful case for the value of ISDS in encouraging cross-border investment trade as well. If it ain't broke, as they say, perhaps one shouldn't try and fix it. But there are voices that suggest there may be a need for some fixes. Tafatswa, your thoughts about areas where, not that ISDS should be abolished, but instead where reform might be useful. What are your thoughts on that?
Yeah, thank you, Gary. I agree with Nigel that the system of ISDS is certainly alive, but there's really no question that it's shifted and it's evolving, and it was broken for many within the system, and they are being pushed to fix it by civil society members. It's alive, but there's certainly a rebalancing of rights and obligations and responsibilities and opportunities that it brings and protections it brings for states and investors. And you see that all over the world, but focusing on Latin America and the Americas. And I think you really have to see the new USMCA, the US-Mexico agreement, as an indication of where things have come. This has replaced NAFTA, of course, and this year, in July 2020, it entered into force, and it really sharply curtails investor-state arbitration compared to NAFTA. In particular, it eliminates altogether Canadian investors being able to gain protections in US and Mexico, and US and Mexican investors being able to receive investment protections in Canada. So it's limited to just US and Mexican investors. And then when you look at the kinds of protections that they can receive under it, unless they are in protected, specific covered sectors such as oil and gas, telecommunications, and power generation, they will no longer be able to file FET claims. Fair and equitable treatment is, of course, one of the, I think it's the claim that has led to the most claims against states, and that will no longer be available for investors under the USMCA unless they are part of those. The dispute concerns one of those small categories of covered sectors. This is the case also with indirect expropriation. It's just not on the table anymore. FPS either. So you're seeing limiting substantive protections, and then also procedurally, investors will only be able to gain protections under the USMCA when they've tried to resolve their dispute domestically, and they've reached the highest court domestically before being able to turn to ISDS. So that's just one indication that the system hasn't really worked. It's challenged certain states in trying to regulate, and they are being pushed by civil society to change the system, and it is changing.
Fadza, if you let me just push you on that, I'm sure that Nigel is thinking right now that that's not an indication of how the system hasn't worked. Instead, it's an indication of efforts to dramatically curtail a system that in fact was working. Why do we think that that the system wasn't working?
I think it didn't work for many, in particular, many developing countries, because they felt hamstrung to develop and to regulate in a way that advances their interest. I mean, I think we've Foley Hoag, my firm, has represented Uruguay in a number of its investment arbitrations, and it's an example. They've won all three of their cases so far before ICSID, but it's been a challenge. In the first one, the Philip Morris case, they needed third-party funding to be able to defend themselves. Speaking of third-party funding, and in the most recent one that they won, they were being challenged because of a mining regulation that they'd put into place to ensure that mining happens in a way that is consistent with everything else that the country stands for in terms of the environment and social issues. And then were sued for $4 billion for it. And so they really felt limited by the extent to which they can regulate. And thankfully it's worked out. They won. The legal fees are partly covered, but it really, for developing countries, often they feel a limitation in how they are fulfilling some of their other international obligations related to the environment, social issues, and development in general, because of this fear that they will be sued for billions of dollars, and maybe it wouldn't have been worth it in the first place.
Nigel, I think it's only fair to come back to you briefly.
Yeah, no, I mean, I think, to add to what I was saying, I mean, clearly there are issues with any system that need to be refined and need to be looked at. And we're seeing that with the latest generation of BITs, where they're very explicit about certain freedom to regulate, which frankly, you interpret the case law in a certain way where they're already, but which rebalance. And I get that. I think what's been unfair is that the system has been blamed for adventurous claims. And adventurous claims can happen in any country, in any system. But the fact that I decide, I mean, for example, the way in which Philip Morris or the Vattenfall case have been used as sort of the standard bearers of, isn't this an outrageous system? They're telling Germany it can't stop nuclear power, or they're trying to influence tobacco packaging. These cases have been largely rejected. And so I think if you're going to have a fair debate, you have to have a fair debate about what the decisions are, not about what adventurous claimants may or may not decide to do. And I think that's important, because otherwise, one could look at all of the crazy claims that are brought in the US courts without saying that the US court system is crazy and we should shut down the courts. I think there's a balancing there. And I've acted for both investors and states, and I've seen both sides of the coin. Most states have not denounced their treaty networks unless it's been a sort of die on your sword, sort of political statement like it was in certain Latin American countries. But Argentina, that was sued multiple times, 50 odd cases, has maintained its treaty network. The same treaties there today as were there at the height of it being the number one respondent in cases. And so you must ask yourself the question, notwithstanding that the government has moved from left to right, back to left again, those treaties remain in place. Why is that? And that's because obviously there is, a responsible government should undertake that balancing exercise. Am I getting more out of this than it's costing me? And presumably when they've done that exercise, they've reached the conclusion, actually, yes, I don't like losing these cases, or I don't like having to pay up, but ultimately it provides the sufficient degree of confidence in investing in my state that I'm prepared to take that risk. So I think it's, absolutely one needs to fiddle around the edges, look at ways in which it can become more accountable, more transparent. I don't have much problem with transparency of proceedings, but that the system itself, let's remember where it came from. It came from a time when the only way you would resolve these disputes is by getting your home state to sue the host state, which was completely unfair for small investors that had been badly treated and couldn't get that diplomatic protection. And, where are we going to go back to if we start whittling away at ISDS? And just one thing on USMCA, I think USMCA, there's so many political questions there that really have nothing to do with ultimately whether the system's working or not, but much more to do with, I don't want to give power to international tribunals. I mean, obviously, USMCA came out of the Republican administration, amongst other things. Canada, probably was quite, to some degree, quite pleased that it wasn't going to be sued by US investors. Still has all of the options open to it under the CPTPP with regard to Mexico, so it can still sue Mexico under another treaty. So, ultimately, I'm not sure that that was all about sort of protecting America against claims or protecting Canada against claims, as opposed to something broader, which was, trade agreements, investment agreements have not been the flavor of the month as the world has begun to look inwards. But it's a constantly moving area, and I completely agree that one must constantly look at ways to improve the system to make sure that states feel they're getting a fair shot. But of course, ultimately, if they don't feel that, then the system would collapse because there's nothing stopping states from denouncing these treaties.
While we're on the topic of ISDS reforms, let's turn to Julie. Can you tell us about recent trends with fork in the road provisions in bilateral investment treaties, Julie?
I think that, it might help if we actually looked at some of these older models of clauses, Gary, and we can contrast them with the more recent ones. I think it allows us to put them in perspective. So, fork in the road, what are we talking about? We're talking about states putting some limits on what investors can do by way of domestic remedies in comparison with international treaties. Fork in the road provisions are contained in international treaties, providing for the international remedies, but they may put some limits on the ability of investors to bring claims under the treaties if they also have proceedings on the ground. So the more traditional historical type of provisions that we have seen, originally they actually were more permissive for investors and less restrictive. If you take, for example, the Mexico-France BIT of the late 90s of 1998, what you see there is the language of the treaty says the investor may bring an investor state claim under the treaty, but the investor may not allege that the state has breached, quote, an obligation under this agreement in a proceeding before a competent court or an administrative tribunal of the state, of the national state in question. So what this means is if an investor is formulating a claim for a breach of the treaty under both a domestic remedy and international claim, that is excluded. But this language, as anyone immediately sees, and also it has been construed, it allows an investor to avail itself of other domestic local remedies so long as they do not constitute, quote, a breach or an allegation of breach of the treaty itself. And that is considered to be a fork in the road that is more limited, i.e. less restrictive of the ability of the investor to bring a treaty claim.
So the investor could basically bring claims arising out of the same conduct by the state in two different forums, in national courts under national law and in the international forum, the ISDS forum, under the relevant bilateral investment treaty, at least under that type of provision.
Under that type of provision, and tribunals carry out these type of analyses of the so-called triple identity, whether we're talking about the same parties, the subject matter, etc. But when the text is restricted to an actual allegation of the breach of the treaty, it certainly makes it easier for the investor to have proceedings that run in parallel domestically and internationally.
While we're on the topic of recent developments, which is the theme of this session, what about recent developments in fork in the road provisions? How has that restrictive provision held up over the last 5 years or so?
Right. So over time, what states have done is by and large to restrict further the ability of investors to bring international claims in parallel with domestic claims. And the language of the treaties has evolved in many places. If you continue with the Mexico treaties, the later treaties will provide for the ability of the investor to bring a claim internationally only if certain things are not done domestically, and there's many of them. So there's in many treaties, the investor is prevented from seeking damages in both a domestic and an international proceeding. And that's spelled out very clearly, which preserves the ability, which is not insignificant, for many investors to bring proceedings looking for the measure, for example, to be enjoined, addressing the constitutionality or lack of constitutionality of certain measures. And those provisions are quite important. If you look at perhaps one of the most recent iteration of this concept of fork in the road, you might consider looking at the USMCA, which replaced NAFTA, of course, the trade agreement among the United States, Mexico, and Canada. And there, what you will find is a treaty that provides for a mandatory litigation of the claims for some period of time, combined with fork in the road, which is the inability of pursue those domestic claims if the international claims are instead adopted. So this is perhaps the more original form of these concepts that marries an obligation to bring domestic claims on the one hand before any treaty claims can be commenced, but it is married with a subsequent fork in the road that is quite severe in its own right.
One's tempted to say that the state seems to want to have its fork and eat it too. Let's pick up on something that both Tafadzwa and Nigel mentioned, which is the flow of Asian investment into Latin America. Karina and Lengsan, your thoughts on that? Are the SIAC investment arbitration rules things that both Latin American and Asian parties ought to think about in that context? Perhaps, Karina, you first, and then Lengsan.
Yes, definitely, Gary. Actually, I'm really jealous about even ICDS cases, because Brazil, in the end, has adopted the option to have private agreements among the state and investors, and this is the way that the money flows in. So we don't have a general protection to investors. But when we see, for example, some aspects of those disputes that could make a difference in like transparency, for example. So in arbitrations involving investors, most of the cases are subject to confidentiality, and we don't know in Brazil currently which are the position of the arbitrators in regard to corporate matters and in regard to corruption that has happened in the country in contracts involving infrastructure, mining, and so many issues that have an impact on investors. And when you see that transparency is the rule in most of, I think it's the rule, right, in the ICDS cases, this could be an actual important development for Brazilian arbitration and in regards to international law. And then I definitely think that even though it's just commercial cases that we have here, we could use many of the rules that SIAC already have and implement those here in our cases. Yeah.
That's a fascinating observation, Karina. The notion that ISDS, in a sense, doesn't hurt states, but rather provides an incentive, a mechanism to enhance good governance, improve the quality of government, whether through transparency of the arbitral process, education of civil servants, as Nigel mentioned, or otherwise. Lengsan, your thoughts on that topic from a Singaporean perspective?
That is actually a very good point to pick up on the main difference between investment arbitration rules and commercial arbitration rules. And with the increasingly, the increased support for transparency in investment arbitration, I think it's natural that people find investment arbitration rules that have provisions for third parties to be heard, amicus curiae or interest groups, subject to the discretion of the tribunal to admit them, would be quite useful. And in this regard, the SIC investment arbitration rules are, I think, a very useful option for investor-state disputes because it is administered, and whereas the ancestral rules are not administered, and it has been updated to allow for interest groups to be heard, to apply to the tribunal to be heard. And I think it can fulfill that niche where investors and states are trying to find the best way to deal with their disputes. And traditionally, they are stuck between an ISDS model or non-administered ancestral model. They now have more options to go before arbitration institutions that offer an administered arbitration, but with features of investment arbitration rules. So I think it does offer a very good option. And increasingly in SIC, we are beginning to see more and more of those investment-related disputes, even some coming before the Singapore courts. And the Singapore courts have been dealing with arbitrations that started as an investor-state dispute as well.
Tafatwa, back to you on the subject of amicus curiae in investment arbitration. Is that a good thing, a bad thing, or an indifferent thing?
It's a good question, and the extent to which it's helpful, I think, depends on the particular case and dispute. But I think it does address one of the concerns, the legitimacy concerns that have been raised about ISDS in general, because it allows more people to be involved and to chime in on issues that have ramifications broadly in that country, or even just the understanding that the states, looking, for example, at CAFTA, they allow amicus curiae submissions from actually also state parties. And so at least allowing them to explain what they meant by certain provisions and to chime in, I think that's helpful. It just allows buy-in from society that could help see that the system is not as the perception that some have about the system isn't quite what it is, and bring in a new perspective. So I think it's a positive development.
It is fairly striking that investment arbitration is one of the international adjudicative mechanisms where amicus curiae participation is most developed and also most frequently used when you compare it to other types of international tribunals. It's also interesting that many of the developments there occurred at the hands of arbitral tribunals themselves, using sometimes rather creative interpretations of either the UNCITRAL rules or other rules where there wasn't any reference, or frankly during the drafting process, any thought of amicus curiae participation, all aimed at trying to enhance legitimacy of the system, encourage participation. Back to you, Nigel, just quickly, and then Karina. Is that a good thing, though? Is amicus curiae a double-edged sword, or is it only for the good?
I was involved in the Suez, Argentina case where amicus curiae were first admitted by the tribunal using their general powers under the ICSID rules before it became part of the 2010 amendment. So I can argue we had the first experience of amici curiae. I think amici curiae are useful, or can be useful, but there needs to be access to the file, because I think the problem was that sometimes there's this hybrid approach where the amici themselves don't really understand what the case is about, and therefore you don't really get a very helpful contribution. Generally, the other problem I think we've come across is that we need to be sure that these are genuine amici, because sometimes we've seen in some cases where these are effectively funded by or alternative ways for the state to make its case. I mean, you have two sophisticated parties. The state has been elected, the government has been elected to defend the interests of that state. It has access to everything it needs in order to defend the state. So in theory, there should be, most things the state should have at its control. But clearly, in some circumstances, there may be issues that are relevant to amici. It's important to look at what the investor is claiming for, because in many cases, for example, in extractive projects, etc., if the claim is not that the extractive project continues, but that effectively, what's happened is that the state has gone back on its commitment to allow the project to continue, and that the project has now been terminated, and what's being sought is compensation, then certain amici, for example, presentations on we shouldn't allow this project to continue because because of environmental reasons, when that's exactly what the state has said, doesn't necessarily add that much. But look, I think that increasing transparency is with us. I think that provided they're properly controlled and are from relevant parties, because that's the other question, is this just a general San Francisco NGO that's beating up on the multinationals, or is it someone, an institution or an organization that has direct local knowledge and which can add a new perspective? Then I think that's a very different sort of proposal, because you could kill investment arbitration if in every arbitration you had 10 multinational NGOs coming in and trying to stall the process. If it's something done in good faith with an entity which clearly has a specific perspective which the state itself would not have, then provided it's carefully controlled, then I don't see an objection. And also, as Tefatul was saying, in terms of DR-CAFTA, when I was defending Guatemala in a number of cases, I mean, the other states did participate, including the United States, as to what the meaning of certain or understanding with regard to certain provisions were. And again, that's quite novel, but it's something that can be helpful, although you have to be, as always, careful about issues that come up where states see specific interests at the time of the dispute that weren't necessarily there at the time when the treaty was drafted, and therefore the tribunal needs to be aware of that. But carefully controlled, I don't think it's destroyed the system, and I think it can inform the system and give the system greater credibility and make it easier to defend with civil society. So in that sense, I think it can be a good thing.
Karina, coming back to you for a Brazilian and Latin American perspective on both this topic, amicus curiae, but also confidentiality in investment and commercial arbitration. Your thoughts before we end the session.
So amicus curiae is very well known in Brazil, but just before courts. The Supreme Courts here deal with a number of class actions and cases that have impacted investors or environment, and then we do have NGOs, but then you have full transparency because those are public proceedings. Because most of the cases involving disputes with the state and investors in Brazil are commercial cases and subject to confidentiality and subject to consent. We wouldn't have amicus curiae being a party, participating in those proceedings, in those arbitral proceedings, and this goes also to the confidentiality and transparency issue. And it is there are some institutions here in Brazil, for example, the Brazilian SIAC, that are worried to develop more and more regulation that obliges publicly owned companies or any company that has the state as a controlling shareholders when it comes to a commercial arbitration involving investors, that there should be disclosure of what is the scope of the arbitration, which are the accusations, which are the arguments, which are the interests that are being protected from investors, so others could join. And we think that this is a very important issue that we should push forward and try to follow the trend of ICDS while we don't have it, while we wait for the treaties to come.
Well, hopefully when we have our next session of this webinar series, we'll be able to discuss a different set of developments in Brazil, fingers crossed. At this point, though, it falls to me to thank all of the panelists for their very thoughtful and insightful contributions. I think all of us have benefited greatly from that. This session underscores SIAC's long-term commitment to the region, to Latin America. SIAC is not an institution that engages in glitzy marketing or short-term efforts. This is a long-term substantive commitment to to engaging with international arbitration in Latin America, engaging with business in Latin America, engaging with the states in Latin America in order to make the international dispute resolution system work better, both in the region and elsewhere. We look forward to, with our Latin American Users Council and with you, our attendees, working together to do just that. Until our next session, thank you.
Thank you very much to our distinguished speakers for gracing us with your presence at today's New York office launch. This marks the close of the program, but the beginning of SIAC's sustained engagement with the Americas. We will be offering not only a bricks and mortar presence in New York, but also a commitment to meeting and exceeding the dispute resolution needs of users from the United States, Latin America, and Canada. Having previously served as counsel in the SIAC Secretariat alongside our Canadian Deputy Registrar and Center Director, Kevin Nash, I can speak from experience of the dynamic way that case management operates at SIAC. We are service-oriented and user-first, whether we are administering a $500,000 case or a $5 billion case. We offer a customized case management experience that is commercial and specifically tailored to the color and complexities of the case. With our president and vice presidents located in London, Singapore, and New York, as well as SIAC court members working out of New York, Washington, D.C., and jurisdictions around the world, time zones are really just a number, and SIAC is always open for business. And with that, I invite you to file your cases with us on Eastern Standard Time with confidence.
Maybe the best way to introduce SIAC's case management expertise is to provide examples of representative cases at SIAC. In addition to administering thousands of international commercial cases under the SIAC rules, SIAC was the first commercial institution to publish specialized investment arbitration rules for cases involving states, state-controlled entities, and intergovernmental organizations. As counsel at SIAC, Adriana's case portfolio included many or most of these investment cases, and she has developed a keen understanding of the issues unique to international investment arbitration. On the commercial side, Adriana worked on high-value disputes and contentious bet-the-company cases, where she learned to balance the practical commercial side of things with the obligation of the institution to administer in accordance with its rules and ensure the smooth running of the arbitration. I can recall cases with specific, very challenging timelines ensconced in the clause where Adriana, working with the president and the SIAC court, was able to ensure that the arbitral procedure remained in accordance with the agreement of the parties. Adriana also assisted with the drafting of the SIAC Rules 2016 and the SIAC Investment Arbitration Rules 2017, as well as authoring briefs on every procedural mechanism available under the SIAC rules, including prima facie decisions on jurisdiction, emergency arbitration, expedited procedure, joinder, consolidation, challenges to arbitrators, and the scrutiny of awards. This case management experience will be an enormous advantage for users liaising with Adriana in SIAC's New York office. She knows how to apply the rules, and she knows how things actually work in practice. More broadly, across case management, SIAC always stands ready to deal with the most complex procedural issues in arbitration with speed and sophistication. Let me run through some examples that regularly come before the SIAC Secretariat. Commencing cases up against limitation periods, dealing with urgent applications for joinder and consolidation within the context of an application for the appointment of an emergency arbitrator, appointing emergency arbitrators around the clock, appointing the best arbitrators in the world, wherever they are in the world, with speed and transparency, and taking into account the diverse characteristics of our users' base. Reviewing and approving awards, SIAC, of course, has a scrutiny process. This is done day and night with a view to multiple potential places of enforcement. This is case management at SIAC. We are an international team of disputes lawyers, qualified in jurisdictions around the world, who are committed to providing best-in-class case management services.
Thank you, Kevin, and thank you to all of our attendees for joining us to celebrate this important next phase for SIAC. I look forward to working with all of you.